Welcome everyone. Welcome to the 4IP Council's webinar, Antisuit and Antisuit Injunctions in SEP litigation. My name is Axel Frazzini, and I'm the Managing Director of 4IP, and I will be your host today. So, as you may know, 4IP is a not-for-profit organization, and we do research activities focused on the link between IP and innovation. To identify the most relevant topics and produce empirical research, we work closely with a wide variety of academics, experts, IP organizations, and stakeholders. On our website, you can find a range of free material, such as studies, guidelines, summaries of relevant papers, and recordings of our webinars, like the one of today. Moreover, we produce easy-to-digest content, specially tailored for non-IP experts, but also for IP experts, SMEs, and startups. This is free of charge as well. Some examples are interactive graphics and interviews to inspire the SMEs and the entrepreneurs. With this, we aim to assist innovative startups and SMEs to learn how to use IP to grow their businesses. More and more things are increasingly connected thanks to the Internet of Things. To achieve this, standardized technologies are needed, often protected by patents. This is why we have created a case law area with summaries of court cases regarding standardization patents. This section is now also available in Chinese and Japanese, and we have just created a dedicated section in Chinese on the website. Without further delay, please allow me to introduce our great speaker, Dr. Igor Nikolic. Dr. Igor Nikolic is a research fellow at EUI. He specializes and writes in the areas of intellectual property rights, competition law, standard essential patents, innovation, and technical standardization, competition, and digital economy. A final remark. Please do not hesitate to use the Q&A tool to submit your live questions along the presentation. You can find this section at the lower part of the screen, and you can raise your questions anytime during and after the presentation. We will then, around 4:30, we will take the questions. So if you are the first asking your question, chances are that your question will be covered. So don't rush, but please don't wait too much. And to move on, without further ado, Igor, the floor is yours.
Thank you, Axel. Well, to start with, those of you that are following SEP disputes, you may have noticed the recent headlines about anti-suit injunction, anti-suit, and even more anti prefixes going before injunction. So what is actually happening? What are anti-suit injunctions? Why are we having their increased use in jurisdictions all around the world? That is the intention of this short webinar. So my aim in this presentation is to present a legal framework. What are anti-suit injunctions and anti-suit injunctions? How are they being used in SEP litigation? And in the end, we can discuss about some proposals how to reduce this global jurisdictional battle in SEP disputes, and how perhaps to incentivize parties to litigate what is actually the core of every SEP dispute, which are FRAND licensing terms. So to start with, what are anti-suit injunctions? Well, it's an order from one court to the party not to pursue or not to commence proceedings abroad. So it is a remedy which is targeted to the party, not to the foreign court, but the effect is basically that party will stop litigating and commencing proceedings abroad, because if they fail to comply with anti-suit injunction, they will be fined for contempt of the court, which may be fines or maybe imprisonment of officials. Now, anti-suit injunctions originated from the UK, and we can find them mostly common law countries. So they are used in the UK, in the US. Where we can find mostly anti-suit injunctions are in arbitrations. So they are a way to secure the compliance with arbitration clause by preventing litigation in the courts, but then giving right to the arbitration. They are also used to secure the contractual choice of forum clause. So, for example, if agreement provides for exclusive jurisdiction of the UK court, the UK court may grant anti-suit injunction to give effect to that clause. We see anti-suit injunctions also in some cross-border disputes, in maritime, insurance, insolvency, but they have not yet been used, as far as I know, in patents and SEP disputes too much. Now, in my paper, the presentation is based on my paper, which will be published, I believe, next week. And in the paper, I discussed legally what are the conditions in the UK and in the US of granting anti-suit injunctions. Now, I will not go into too many details about the legal conditions here, but suffice to say that both in the UK and the US, anti-suit injunctions are granted on the discretion of the court, and they have some criteria how they exercise that discretion. Typically, anti-suit injunction is granted when there are overlapping, where there is parallel litigation, the parties are the same, and adjudication would dispose of a foreign suit, or when there is an overlap, but the foreign proceedings are vexatious or oppressive. Now, in each jurisdiction in the US and the UK, a special legal test is that anti-suit injunctions must not be against the principle of international comity. And comity is the kind of an elastic concept which requires the courts and countries to show each other mutual courtesy and respect. So in the US, we have, for example, a split decision between kind of three different interpretations. What does respect of comity mean? Some courts give a lot of deference to international comity and would order anti-suit injunctions only exceptionally. Some courts are more liberal and only ask whether there is a tolerable impact on comedy, and some courts are in the middle, having a rebuttable presumption that anti-suit injunctions are against international comity, but then the applicant has to provide justification why the anti-suit injunctions would be justified. So, and in Europe, in civil law systems, we don't have too much anti-suit injunctions. They're relatively uncommon and unknown. European jurisdictions or civil law systems see them generally as against right to access to court, right to access to property, to be heard by a judge. It's against their constitutional traditions. And typically when they're faced with a foreign judgment, they would rather not enforce it than to prevent a foreign court from even adjudicating a case. And in the EU, we have the Brussels regulation on jurisdiction and recognition and enforcement of judgments, which prohibits anti-suit injunctions within the EU. So EU courts don't have the power to prohibit other EU courts, but they are then in principle available against non-EU jurisdictions. But as I mentioned, generally civil law systems are reluctant to grant them. And there is also a special kind of anti-suit injunction which needs to be explained, and that's anti-enforcement injunction. This type of order prohibits only the enforcement of a foreign judgment in a foreign country until the issuing court decides the case. So there is a distinction between anti-suit injunction, which is wider, prohibiting all litigation from commencing or continuing, to a more narrower anti-enforcement injunction, which just prevents the enforcement for a certain period of time. And then the finally anti-suit injunction. Now this is generally being used by European courts, and it is an order restraining a party from seeking or enforcing a foreign anti-suit injunction. So it's a way to defend against foreign anti-suit injunction. So this anti-suit injunction is recognized by civil law countries, but also it is used by common law systems as well. Now, moving past these definitional issues, why do we have anti-suit injunctions and anti-suit injunction in SEP disputes? Well, you may know that currently when we have global companies having global portfolios and implementers operating worldwide, their dispute is basically about a global SEP license. However, the patents are only national, and if negotiations break down, the only way to litigate on the patents is to sue in different jurisdictions, different countries. There is no currently a global tribunal or a global patent that will assess FRAND licensing terms and rates. The second issue is that of those of you that know, some courts have recently started asserting jurisdiction to or determine global FRAND rates. This has started from the UK judgment in Anwar Panet and Huawei, and the UK Supreme Court also said that in that particular case, when there was infringement of a national patent, and they were looking at whether the SEP owner complied with the FRAND commitment, they said that FRAND commitment in that case requires that a license be global. They determined the terms of a global license and issued an injunction unless the implementer accepts a global license. This has, in a way, kind of incentivized other countries to determine global FRAND rates. And we can talk about this question more in the Q&A, but this is kind of led to a race to the court because some jurisdictions are perceived more favorable to SEP owners. Some jurisdictions are perceived more favorable to implementers by awarding lower royalty rates. So in that kind of global jurisdictional battle leads companies to be the first to sue in the most they think is favorable jurisdiction and then ask for anti-suit injunction preventing all other litigation going forward. So what do we actually see? Now in the article, I have analyzed cases from the US, Europe, China, and India, trying to see, well, how many anti-suit injunctions we really have, when are they granted, under what conditions, when are they refused, what is really going on. And often you may hear that the US is a jurisdiction that first granted anti-suit injunctions and that US courts are happy to assert their own jurisdiction at the expense of others. Well, upon closer look, I found that this is not entirely correct. So yes, it is true that the US was the first to issue anti-suit injunctions, but anti-suit injunctions are not that frequent and they are rather an exceptional remedy, and in many more cases they have been refused or not decided. So we cannot really say that it's true that US courts are happy and willing to use them all the time. And as you see in this table, the only time when a full anti-suit injunction was granted was in the TCL versus Ericsson case. And those of you who are more familiar with SEP disputes, they may remember that this is the case where parties agreed that the US court will determine the terms of a global FRAND license, which the court did. And the case was appealed and it was then quashed and so on. But the parties agreed to pause all other their disputes in other jurisdictions and let the US court decide on determining global FRAND terms. And the judge issued an anti-suit injunction based on this mutual consent of the parties. This is kind of a typical case where parties consented to anti-suit injunction and to the jurisdiction of the court to determine FRAND licensing terms. When the parties didn't consent, the courts issued a more limited anti-enforcement injunctions in two cases. Microsoft Motorola, yes, that's the first case in SEP disputes when anti-enforcement injunction was issued. Their Motorola obtained injunction in Germany for the infringement of its SEP, but prior to that, the litigation was ongoing in the US, and the parties agreed on a bench trial for a judge to determine, again, the terms of a global FRAND license. And in that case, the judge said that anti-enforcement injunction is justified, that since both parties are American companies, the dispute first started in the US, they will determine global licensing terms, then that may justify prohibiting enforcement of patent injunctions, but they say in terms of comity, we don't prohibit German litigation going on different matters like validity of patents, damages, and others. Again, in Huawei versus Samsung, Huawei obtained injunction against Samsung in China, and then Samsung asked for anti-enforcement injunction and was for similar reasons managed to obtain. Then in more cases, we see that anti-suit injunctions were refused. So for example, in Ringo versus ZTE, a dispute there was about in the US and China. In China, it was about whether the SEP owner abused dominant position, and in the US, it was whether the implementer infringed on the breached non-disclosure agreement, and Ringo asked for anti-suit injunction in the US to prohibit litigation in China, and the court said no, these are two different matters. There is an antitrust case in China, we cannot, impact on the committee would be intolerable. Then there is Apple versus Qualcomm case. So Apple sued Qualcomm based on non-infringement of patents, breach of contract, antitrust allegations in the US, in Taiwan, in China, Japan, South Korea, and Qualcomm asked for anti-suit injunction, and the court refused, saying, well, it would be, again, intolerable effect on comity because it would deprive other courts to adjudicate whether Qualcomm's actions have an anti-competitive effects in their territories. It would prohibit courts to assess the validity and infringement of their national patents and denied an injunction. Similarly, in Optis versus Huawei, the court denied an anti-suit injunction because it thought this in China was about Chinese patents, US was US patents. And in two more cases, anti-suit injunctions were requested but not decided, because we will see later, because European courts issued anti-suit injunction. But it would be interesting to see what would have US court decided, having all these precedents in mind. Now in Europe, we have completely different picture. There are no anti-suit injunctions. European courts don't want to get involved in prohibiting other courts deciding their matters, their disputes, but they protect their own jurisdiction by the grant of anti-suit injunctions. Now, I will not go into detail of all these cases. You can read it in my article for those who want to know more. But generally, the courts use the justification for anti-suit injunction that they are contrary to their public order, they're contrary to fundamental rights to property. They are the only competent courts to examine the validity and infringement of national patent, the right to access the courts. Their citizens, companies must have the right to petition the court, have the case heard by the court. And more recently, we have two anti-suit injunctions refused, but they are refused because, you will see later in these cases, This is an example of kind of preemptive anti-suit injunction, when there was not yet any anti-suit injunction request, but they asked preemptively and the courts refused, saying, well, let's first wait until there is some anti-suit injunction, then we'll grant anti-suit injunction. So that's in Europe. And what happened in China? Actually, the Chinese position is what triggered mostly these debates about global jurisdictional battles and who is the which court is most appropriate to determine FRAND licensing terms. And there in China, we can distinguish again an anti-enforcement injunction in Conversant versus Huawei, and a much more wider anti-suit injunctions in 3 later cases. And what can be found when reading the judgment, looking at the case, is that the first case of anti-enforcement injunction was similar to the conditions that were used by the US courts, while the other anti-suit injunctions that were much wider kind of departed from the traditional criteria used in the US, in the UK. So let's see a bit in more detail what happened in China. So a dispute broke up between Conversant and Huawei. Huawei first sued in the US. They wanted to know whether the Conversant patents are infringed and valid, and for a court to determine a royalty rate for those patents. Conversant sued in Germany, obtained an injunction, and then Huawei asked for anti-enforcement injunction, which was granted. And when you read the judgment, you see that the Supreme People's Court in China used criteria similar to the one that the American court would use. They say that the German injunction would interfere with the Chinese proceedings. Anti-enforcement injunction will not affect comity because the Chinese action was brought first before the German one, and it doesn't prevent other claims in Germany going ahead, just the enforcement, until they determine the royalty rate. Whether that's justified or not, we can talk in the Q&A. But it is in these 2 cases, Xiaomi versus InterDigital, and later Samsung versus Ericsson, which really saw the widest possible anti-suit injunctions. So there, Xiaomi asked for the Wuhan court in China to determine their global FRAND licensing terms. InterDigital replied by suing in India, and then Xiaomi asked for anti-suit injunction, which was granted. And it was much wider than before. It asked InterDigital to withdraw request for injunction in India, then prohibited any injunction proceedings on SEPs anywhere in the world, and prohibited bringing any lawsuit anywhere in the world requesting the determination of FRAND royalty rates. And criteria for this, justification for this judgment were basically of efficiency. So the court said it would be more efficient if one court determined FRAND licensing terms. There would be conflicting judgments if you have more courts working in parallel. There would be harm to Xiaomi if there is for an injunction, while harm to InterDigital, they said it's only about waiting until they decide what are the FRAND licensing terms. Then in the next case, Samsung versus Ericsson, that was even wider anti-suit injunction. So Samsung sued Ericsson again in Wuhan, asked for anti-suit injunctions, and obtained it. Again, the Wuhan court prohibited seeking injunctive relief anywhere in the world, requesting from any court anywhere in the world to determine FRAND licensing terms, then prohibited seeking determination whether Samsung breached its FRAND obligation, and also prohibited seeking anti-suit injunction as well, until they determine FRAND royalty terms. Now, not going too much into the details, this resulted in response. India granted anti-suit injunction, the US court granted anti-suit injunction, and in the end, in both those cases, parties settled. So, And in Germany, what we see is an attempt of German court to kind of put a stop to anti-suit injunction. And in InterDigital versus Xiaomi, the German court granted anti-suit injunction against ASI in China, but it also said a few principles. One is that they may preemptively grant anti-suit injunction, and here are the criteria when they can do that. So there are very wide criteria saying they can grant anti-suit injunction even when implementer threatens to file an ASI, if it brings an action, so patent, maybe patent invalidity, non-infringement action, jurisdiction when anti-suit injunctions can't be granted, if he has already threatened to file an anti-suit injunction before, and if it has failed to declare in writing a short deadline that will not request an anti-suit injunction. So very strict criteria when they can grant preemptively. And they said, secondly, as a consequences, implementer who threatens to file or files an anti-suit injunction will be treated as an unwilling licensee. And in Europe, that means that within Huawei versus ZTE framework, if there is a presumption that an implementer is an unwilling licensee, then other criteria of Huawei versus ZTE do not need to be discussed, assessed, and court may proceed to give an injunction immediately once they find infringement. So this approach has been then applied in IP Bridge versus Huawei, with which granted preemptively anti-suit injunction. And it appears that for now, this German approach has stopped global jurisdictional battles and filing of anti-suit injunctions. We haven't seen it yet, but that may change. Finally, why are this? What's the effects of all these races to anti-suit injunction, to global jurisdictional battle between courts who will assume jurisdiction? Well, the effects to the whole system and to the companies is legal uncertainty. We don't know which court will be ultimately competent to hear the case. Where will the case be decided? Another consequence is that we are seeing a race to the court. So instead of trying maybe to negotiate in good faith, parties are racing to be the first to sue in the most favorable jurisdiction and secure an anti-suit injunction, which as a consequence raises litigation costs. So you have to defend yourself against many jurisdictions. You need to ask for anti-suit injunction in many other jurisdictions, which doesn't really solve your problem. It just delays it while you're in this jurisdictional battle. And finally, the biggest paradoxical consequence is if you fail to comply with anti-suit injunction or anti-suit injunction, officials may face imprisonment, companies face fines. So it will be a paradox that company officials, directors would be imprisoned basically for what is a licensing dispute. And finally, to discuss what can we do about it. Well, where are we heading? How to avoid this? Well, first of my proposal is to exercise judicial restraint. And as I explained at the beginning of the presentation, anti-suit injunctions really are an exceptional remedy ordered only in exceptional circumstances. So we should go back to this original criteria and really order them in exceptional circumstances. Now, in SEP cases, it is my belief that anti-suit injunctions preventing foreign patent litigation should not be granted. This is because they infringe on property rights, access to court, and national courts should have jurisdiction to determine the valid infringement of their own national patents. Now, that being said, I believe there is a room for anti-enforcement injunctions, again in exceptional circumstances which exist. So basically, I believe that anti-enforcement injunctions could be considered when there is the strong connection with the issuing court. For example, they are all domestic parties, or it's an headquarters of the defendant. If foreign proceedings are obviously frivolous and vexatious, and when there is a short duration. So a problem may be that if you ask anti-enforcement injunction, and then you are in the jurisdiction which is the slowest, you may basically drag on litigation. So it has to become this time lap that any anti-enforcement injunction will last for a relatively short duration. Then another proposal that I think is to look at the German proposal into more detail, where they said that antisuit injunction is a sign of unwillingness to license. Now, an argument could be made that this is too harsh, that you kind of conflate, maybe there are reasons when this antisuit injunction will be justified, it is too harsh, too broad. But as I said, antisuit injunctions, in my view, they have no place in SEP litigation, and they are an additional deterrent of seeking antisuit injunctions, but we should recognize that anti-enforcement injunction may exceptionally be used, and that may be allowed. But the final and ultimate solution, even if you don't use antisuit injunctions, we are faced with all courts trying to fight who is going to be the first one to determine the terms of a global FRAND license. Yes, that is the result. And I think to overcome this is to facilitate arbitration. By arbitration, companies are free to select arbitrators, agree where to arbitrate, and they can determine what is actually the core of the dispute, what are the appropriate FRAND licensing terms. They can do it more efficiently, cost-effectively than multiple national litigation. And there are different ways to kind of facilitate arbitration. A short-term solution may be following German courts to have rebuttable presumption of unwillingness to license for a refusal to enter into an arbitration agreement. That would apply both to SEP owner or an implementer. So if there is unjustified refusal that is found to be genuinely delaying and not wanting genuinely to settle the dispute by the arbitration, there can be presumption of unwillingness to license. And in this kind of method, that may incentivize parties to genuinely try to find an agreement on arbitration. The long-term solution would be, and this was proposed and examined by many, to have specialized arbitration of FRAND terms by the standard development organization that would be tasked better to determine the terms of a FRAND license for their own standards. And that sounds good, but the problem is it's a bit utopistic, and such solution would require the consent of too many parties, and I don't see that happening in a short term. There is also a problem on methodologies, what arbitrators would use. Do you use top-down approach? Do you use bottom-up approach? How do you do it? So this is something that may disincentivize members to agree. There is a question of access to courts, where you need to have access to courts. But I believe if arbitration is just about FRAND licensing terms, then the parties would be free to then litigate infringement and validity of national patents, and that may feed into the royalty rate. So those are the proposals to discuss. But ultimately, in my opinion, the way how to overcome global jurisdictional battles is not having a court issuing antisuit injunction and assuming global jurisdiction, but instead having parties find their own way between themselves in mediation or in arbitration to resolve their dispute. So thank you, Axel. Do we have questions?
Thank you very much, Igor. Yes, we have questions, and we will start with the easiest one. That's my judgment. On the slide 14, it was talking about ASI and AASI in SEP litigation in Europe. and 2 anti-suit injunction were refused, but there was no indication related to which jurisdiction. Do you remember?
Yes, Ericsson versus Apple, this was in Netherlands, and this GI video against Xiaomi was in Germany, in Düsseldorf.
Okay, thank you. So this was easy.
Easy.
Second one is, if there are no anti-suit injunctions, does not it mean parties will race to the fastest court, in your opinion?
Yes, that's possible. That's possible, but again, that's the outcome that we have, and they may go to the fastest court, maybe go to the court they see most favorable, and then try to speed up the process. And that's why I think maybe it would be better to facilitate arbitration rather than going into these jurisdictional battles.
So then we have a question related to arbitration. Do you think a global FRAND arbitration tribunal could ever be a possibility as a solution?
I personally would like to. I think it could be possible, but again, it needs good faith from all participants. In my mind, the problem with setting up this arbitration are what methodology the arbitrators would use. So if would arbitrators use top-down methodology, which is kind of estimating what is the aggregate royalty for a standard, and then apportioning it to a different SEP owner, that may be seen as unfavorable to some companies. Do they use comparable licenses? Do they use the value of the downstream technology, the added value it brings to downstream products? So what methodology? And if you pick different methodology, you come to different results. So that's the biggest problem I see, companies agreeing on the methodology the arbitrators would use. And that's why I think maybe the arbitration in some instances failed to form. But again, I hope that companies may come and then find a way to set up the global arbitration.
Okay, this is great. We will cover one last easy question before going to the long questions. So the last easy is, when it arises, and I suppose that will be related to arbitration tribunal, I'm not sure. When it arises, would the European Unified Patent Court be vulnerable for ASIs, or could it issue an ASI? So that's related to the European Unified Patent Court. And the question is, do you think that there may be anti-suit injunctions issued or received?
Antisuit injunctions issued by the Unified Patent Court, right? That would be interesting to see. So I guess you would have to sue first on the unitary patent, and we don't have them yet, right? So in the future, I guess that would be a possibility if you sue it on unitary patent and then ask for a anti-suit injunction. So that's something to see in the future.
Okay, very good. One long question. It could be said that the Unwired Planet versus Huawei case, where the UK court established global FRAND royalty rate, has opened the floodgates for other national courts to determine global rates. Thus, the root of the problem may be that courts are setting global FRAND rates. Then, assuming jurisdiction via anti-suit injunction becomes natural response to potentially conflicting judgment. Maybe an answer to anti-suit injunction and anti-suit injunction problem lies in getting back to national courts setting only national rates?
Yes. So there is an argument that this whole problem with anti-suit injunctions started from the UK's decision in Unwired Planet versus Huawei, where they determined a global FRAND rate for the infringement of a national UK patent. And my opinion is that we have to distinguish between two issues. One is, did the court made a good, correct decision based on the law and facts of the case? And then second, what's the consequence? And I believe the UK court made a good decision. So they have interpreted the ATSI FRAND commitment. They read the text of the FRAND commitment, said that it requires to offer a worldwide license. They looked at the practice in the telecommunication industry where there are worldwide licenses. They looked at the parties, their conduct, who also had worldwide licenses. They say licensing by country, having national country by country licensing would be madness, would be a door to hold out. And taking all this into consideration, they interpreted ATSI's FRAND commitment as requiring a license, worldwide FRAND license. So I think legally they did the correct thing, and it's the correct thing to do. Now the consequence, of course, is that you now have other courts following that. And the other courts also saying, well, we can also determine if FRAND is global, we can determine those terms. And that's correct. But the UK unvalid plan case didn't involve anti-suit injunctions. So that's kind of a consequence, but it's not necessarily to have them. The another consequence, again, is to have all these courts, national courts, litigating, trying to be the first to arrive to a global FRAND license. It's unsatisfactory solution, and solutions can, I think, should be looked at arbitration, mediation, but I don't think that prohibiting other courts from litigating or being the first to sue should be the determinative factor which court will be the ultimate court to set up global FRAND licensing. And in the end, what we can see from all these cases is that parties have settled. So actually an argument could be made that parties don't even want for courts to determine licensing terms. They just use it as a negotiation strategy to impact each other and then arrive at FRAND licensing terms. So in China, parties didn't wait until the Chinese court decided, they settled. In other cases as well. So in the end, we can also ask, do parties really want courts to settle the terms, or it's just a litigation strategy?
That's very interesting. Next one is, do you think that the Munich regional court's approach to anti-suit injunction is too harsh for the implementers? And does it conflate the seeking of anti-suit injunctions in litigation with pre-litigation negotiations under Huawei versus ZTE?
Is it too harsh? It does sound too harsh, but I think it should be kind of an interim approach to stop all these anti-suit and anti-anti-suit litigation of disputes. I don't think it conflates pre-negotiation behavior, because I think Huawei versus ZTE also look at behavior in total up right to the issuance of injunction. And if you threat to issue an injunction, if you have issued it before, if the case is ongoing before you go to Germany, that all comes into assessment of the German courts. And I don't think the court was wrong in that case. So I would say it's a harsh, but I think it's justified approach.
Okay. Another quite long question here. Will you please explain the difference between Microsoft versus Motorola and IPCOM versus Lenovo? In the former, the US court issued anti-enforcement injunction because parties have already agreed US global FRAND setting. In IPCOM versus Lenovo, parties also had agreed US global FRAND setting, but the French and UK courts said that an anti-suit injunction had to be ordered to preserve the SEP owner's right to enforce a right. Which way of thinking do you prefer?
Yeah, just a moment. I'm also reading the question to better understand it. My question is, did they actually agree for the US court to be a global setting? As I would have to check, but if I remember when I was reading it, it was that IPCOM, the Lenovo sued IPCOM for a breach of FRAND commitment and requested the court to determine FRAND terms. So I don't believe that the parties agreed for a UK court to have jurisdiction to determine, but I may be wrong, and I would like if the author can maybe send me a file to correct me. But that being said, let's try to answer the question, assuming the question is correct. Yes, please send me a file later. So assuming the question is correct, I would have preferred the UK and French court decision. So, and also conversely in Microsoft versus Motorola, because if I remember correctly, in the case Microsoft moved its production center away from Germany, so it didn't quite impact its production. And also now, but Microsoft and Motorola case was before Huawei versus ZTE, and then Germany, they had an Orange Book standard for looking at what's the behavior of willing licensee and licensor. So now in Germany, if this would happen, Motorola would have to explain why its offer is FRAND and why it's to justify it. So we would have kind of both assessment of FRAND offers in the US case and in the German case. And Microsoft Motorola was before Huawei versus ZTE, so Motorola didn't have that obligation. By the Orange Book standard, I remember it was on the implementer to show that it's behaving as a willing licensee, to make a FRAND offer, so there was a different standard. But now we would have this kind of convergence that both in the US and in Germany, courts will look at whether the offer was FRAND. And in that situation, which court should have preference? I don't know. I would leave it to the courts.
Okay, very good. So just because they're asking if they can send a file, please send everything to 4IP Council. That's info@4ipcouncil.com, and we will make sure that Igor will receive the file.
Thank you. Thank you.
Thank you. Next, how effectively incentivize parties to accept arbitration, in your opinion?
Sorry, can you please repeat?
How to effectively incentivize parties to accept arbitration?
I believe that judges can do it in the injunction stage. So as the parties, as I said, this was my proposal to have the unwillingness to license standard. As the parties, have you tried to arbitrate? If yes, why the negotiations broke down? If no, then why you didn't want to arbitrate? And in that kind of assessment of willingness to license, to infuse kind of looking at, have they genuinely tried to arbitrate the dispute? For example, in Germany, what the Federal Supreme Court said, that the implementer has to negotiate in target-oriented manner, willing to conclude an agreement. And we could also add this, that parties should maybe in target-oriented manner try to find a way to arbitrate FRAND terms. And that can be an additional argument, an additional incentive for parties to really genuinely try to determine FRAND terms by arbitration or mediation.
Okay, just as a reminder, the slides will be made available tomorrow, and the forthcoming research paper written by Dr. Igor Nikolic will be available in the next few weeks. I think that's in a couple of weeks.
Next week.
Next week, the paper will be available. So you will find a lot of information in the research paper. Moving on to the next question. What are practical distinctions between anti-suit injunction and anti-enforcement injunctions?
Yes, well, as I mentioned, anti-suit injunction is broader, so encompasses all other patent litigation in other countries, and it prohibits companies from initiating them, and if they did initiate, from pursuing them. And anti-enforcement injunction is narrower, so it just prohibits the enforcement of a foreign judgment. So the case can move ahead, and then only when we come to enforcement, it stops. And it stops, in my suggestion, only for a limited period of time. So in my view, the impact on comity of anti-enforcement injunction is smaller, lesser than the full anti-suit injunction.
Okay. Regarding the US cases, can you tell us more about US cases? Why were anti-suit injunctions refused and anti-enforcement injunctions ordered?
Yes. To come back to the US cases, yeah, we have seen that the courts actually look at their criteria for the award of anti-suit injunctions, and those criteria looked at whether the UX action will be dispositive of a foreign one, what is the impact on comity, are the parties the same, are the foreign proceedings vexatious or not. And in those cases where it was refused, I talked about them. So in different ways, the courts kind of gave precedence to the comity concerns. So in Apple versus Qualcomm, the court was saying, well, we cannot prohibit foreign courts determining their applying for their antitrust law to determine the effects of Qualcomm's practices. We cannot prohibit foreign courts for assessing infringement and validity of their patents, even if we would determine global FRAND licensing terms. Still, the foreign courts should have the authority to determine the impact of the impact of actions in the antitrust law. In Optis versus Huawei, we saw that in that case, I think in China, they were determining infringement of Chinese patents and determining national FRAND royalty. In the US, it was about whether the FRAND obligation was respected, infringement of US patents. And the court said actions are similar, but they will not dispose of each other, and the impact of comity, we need to respect Chinese judgments. And anti-enforcement injunctions, they're similar because in both cases we had patent injunction, patent infringement, and patent injunction. So there was a threat that if patent injunction would be enforced, the companies would have to settle. The implementer would have to settle because it pressured because of the injunction. It can be argued, are impact on comity tolerable, or if this would happen because there are proceedings to appeal, and so that can be debated. But the main issue is there was patent injunction which could impact US proceedings, and the US case was about settling global FRAND licensing terms, and then Chinese case was in Huawei for Samsung about national. So there was kind of a battle between one court setting national, another setting global, and then saying the injunction will impact our global litigation. And it's interesting to compare when we have two courts setting global FRAND licensing terms, which court then should have precedent? I don't know. I think it's dangerous to pick and choose which court should have the precedent of determining global FRAND licensing terms.
Okay, very good.
This answers the question.
I think it definitely answers the question. But if we ask the same question regarding European cases, can you tell us a bit more about European cases?
Yes, European cases are mostly about anti-suit injunctions, like I said, and the courts were very afraid of foreign anti-suit injunctions, especially the US ones. So the US, in China, and the European courts see it really as infringement of their own jurisdiction. And they are saying basically that prohibiting them from assessing the infringement of validity of their own national patents, of their own companies and citizens, denying them access to the courts. Well, that's against their constitutional traditions, that's against human rights convention. So they are very, very guarding their own jurisdiction. But on the other hand, to be fair, they are not being offensive. So they are not ordering anti-suit injunctions. So that's kind of the difference. And I can see in the future these cases where courts would, okay, we want to order anti-suit injunction, but there is going to be a race. Which court is going to be the first one to determine global FRAND rates? And we'll see. So maybe that will courts make them efficient, maybe make the system efficient, and maybe they can incentivize parties to settle if they cannot find a way to arbitrate.
Okay, and I received a short message saying on your slide 7, there was a headline saying Munich court confirms anti, I mean, that's 4A suit injunction in SEP battle between InterDigital and Xiaomi. Do you think that's on slide 7? That's getting out of hand. I mean, would it end one day, or what stopped actually them to get an 5A SI at the end?
I'm glad that the audience is following closely my slides and remembering what was in the beginning. Yes, and actually, this is the case of the Munich court which preemptively granted anti-suit injunction. This said principles of preemptive anti-suit injunction and said principles that a company that asks for anti-suit injunction will be presumed and willing to license. So basically, after that, the situation temporarily stopped. So at least stopped companies from asking anti-suit injunctions abroad. And yes, that's a good question. So where does it end? So you can have an ASI, then anti-suit injunctions, then anti-suit injunction. As I said, it can go to nowhere. Companies are spending money on jurisdictional battles. And basically, both of those parties are not complying with the original anti-suit injunction, with the original anti-suit injunction. And if you would enforce them, then both companies would have to pay penalties, and maybe both officials would have to be imprisoned. So it's a paradoxical situation.
Okay, let's try to avoid the prison then. I think we can go back to slide 24, and I have the feeling that we could have continued for hours. Your presentation has been very informative, and I cannot wait to read the full research paper in 2 weeks. But now it's time to conclude, and I would like to thank you very much, Igor, for sharing your knowledge and expertise. Thank you also to all of you for attending this webinar. Later today, you will receive an email inviting you to complete a 1-minute survey about this webinar. That would be great if you can provide some feedback. And as explained before, a recording of this presentation will be made available on 4IP Council's website tomorrow. Don't forget to subscribe to our newsletter to find out more about upcoming webinars. And on the 24th of March, we are delivering a joint webinar with the EU IPO on how IP helps to secure your business investment, and SMEs will learn how to use intellectual property rights to have a business competitive advantage and to secure finance for your business. You can use the QR code to subscribe right away today. Everything is already up and waiting for you. So thank you, Igor, again, and goodbye.
Thank you. Bye-bye.